Welcome to Medical Law and Ethics. This week, week 3, we will be covering confidentiality and consent, ethical challenges, and the HIPAA privacy rule. The behavioral objectives for this week include: you should be able to distinguish between express and implied consent. You should be able to distinguish between privacy regulations and rules and what confidentiality is. You should be able to identify the information that must be disclosed for informed consent to be legal. You should also describe the emergency exception to the informed consent requirement. And then identify who actually can give consent. Behavioral objectives continued. You should also be able to describe the types of health information protected by confidentiality laws. You should be able to explain the general rule regarding ownership of medical records information. You should be able to describe the authority that allows healthcare providers to charge record duplication fees. And finally, you should be able to give examples of state laws that protect the confidentiality of medical records information. Key terms that you should know. Battery. In common law, battery is the unwanted or offensive physical contact with another person. Express consent. This is consent that is given verbally or written. Implied consent. Inferred consent from the person's conduct and presumed in certain types of emergencies. Informed consent. The presentation to the individual of the risks and benefits of a procedure that the person willingly agrees to. The reasonable physician standard. This standard is used to determine the adequacy of information the physician gives in the informed consent process. The reasonable patient standard, used as a standard to determine the adequacy of information the physician gives in the informed consent process. Causation. In legal terms, the burden on the patient to prove that the inadequate information given in informed consent process was the cause of the patient's agreement to proceed with the procedure. Therapeutic privilege. The exception to the informed consent doctrine that permits a physician to withhold information when disclosure would be deemed harmful to the patient. Key terms continued. Competent individual. This is an individual capable of making informed decisions. Incompetent individual. An individual deemed legally or medically unable to make informed decisions. An emancipated minor. That's the legal status of a minor who is no longer under parental control. Mature minor. A minor child who is allowed to make decisions about their own health care. Blanket consents. A type of consent rarely used nowadays that gives the hospital or the healthcare agency the right to perform whatever procedures deemed necessary. These are usually minor procedures, not major procedures. HIPAA, Health Insurance Portability and Accountability Act of 1996, and its further amendments. Protected Health Information, or PHI. This is health information that is protected under HIPAA. Designated records set. The individual's medical records that are maintained by a healthcare entity. More key terms. FOIA, Freedom of Information Act. The Privacy Act of 1974. This establishes a code of fair information practices related to information held on an individual by government agencies. HIPAA preemption. The HIPAA principle that the HIPAA regulations take precedence over state regulations in certain instances. HIPAA covered entity, an entity which complies with the HIPAA regulations by law. HIPAA hybrid entity. Parts of the entity are covered by HIPAA regulations and parts are not. Quality Improvement Organization, or QIO. These are organizations that monitor the effectiveness of Medicare entities under the Centers for Medicare and Medicaid Services. Utilization Review. This is a review of the medical necessity of non-emergency care. Quality Assurance, or QA. This is the systematic monitoring of quality in programs by the agency itself. Notice of privacy practices. This is information provided to the individual related to the uses and disclosure of PHI, personal health information, along with the individual's rights related to their personal health information. Legal theories of consent. Common law in the United States recognizes that the individual has the right to make the decisions about who or who does not touch them, especially in an offensive or harmful way. Touching without consent in the healthcare field is termed battery. Failure to disclose information, however, is termed negligence for the purposes of legal action. Consent is termed either expressed or implied. In expressed consent, the consent is given in writing or orally. However, the oral consent must be witnessed and documented as such. Implied consent is inferred from the patient's actions. Consent is often presumed in emergency situations when the patient is unable to give expressed consent. This applies to life or death situations. Legal theories of consent continued. Informed consent is the process by which the patient is educated to the risks, benefits, outcomes, and then, based on that information, freely consents to the procedure. The information provided and the obtaining of consent is the responsibility of the physician. The physician, or his or her designee, must also chart the process of obtaining the consent. An effective consent form should consist of a voluntary signature, a description of the procedure, and that the patient understood the procedure, risks, and consequences, both of performing the procedure or not performing the procedure. The identity of the person or persons performing the procedure is also required. It is the patient's right to agree or not agree to the personnel performing the procedure, including any associated physicians or any other personnel. Legal theories of consent. Continued. Documentation of consent is required in the following circumstances. If there is an invasive surgical procedure, that is a procedure that cuts into the body itself. ECT, or electroconvulsive therapy. Any experimental procedure. HIV testing. Sterilization. For sterilization, there are many issues of mental competency and eugenics that apply. Abortion, organ donation, and any other procedure as required by individual state laws and or preemptive federal laws. Legal theories of consent continued. The common standards that are applied to determine the adequacy of the information given in the informed consent process are the reasonable physician standard and the reasonable patient standard. In the reasonable physician standard, the physician's duty is to provide information that a reasonable medical practitioner would provide under the same circumstances. In the reasonable patient standard, the information provided is based on the patient's information needs. Both are used in courts. However, the reasonable patient standard has been adopted in many states as well as by the Medicare conditions of participation. Exceptions to the informed consent process include emergency situations where the limiting factor is time. The patient may be able to give consent, but there is no time to completely inform the patient. Therapeutic privilege may also enter into the picture. In therapeutic privilege, the physician may withhold information that he or she deems poses a threat of detriment to the patient. The patient may also waive the informed consent process. Criminal suspects and prisoners are a gray area. The ability of a police officer to request a healthcare practitioner to perform tests on criminal suspects and or prisoners is governed by state law in most cases. Who can give consent? Those who can give informed consent are individuals who are over the age of maturity, 18 in most states. However, the law of the state preempts federal law in this instance. A person who is deemed competent may refuse consent. The person is capable of making decisions unless there is a court order declaring them mentis non compos or mentally incompetent. An incompetent adult is one whose decision-making power regarding their affairs has been given to a guardian or a personal representative. The guardian or personal representative has a narrower range of choices when making decisions. They must know the wishes of the individual, and those wishes must be taken into consideration in the decision. Temporary incompetence, such as that induced by drugs or other factors, may delay the procedure. It is up to the physician or healthcare personnel to make the decision of temporary incompetence. No court order is needed. Who can give consent? Continues. Minor individuals are a special case in terms of informed consent. The definition of a minor is dependent on the state of residence of the minor. Emergency treatment, that treatment that is needed immediately, exempts the healthcare facility from the regulations of informed consent as it would with an adult. Parents or guardians are responsible for the decision-making regarding procedures of a minor. A court may overrule a parent or guardian if deemed necessary for the well-being of the minor. Emancipated minors are governed by state of residence regulations. Types of consent. Here are 3 types of consent forms. The short form, also called the general or battery consent form, described in shortened form the procedure. The form for the individual's signature indicates that the patient has been informed of the necessary conditions of the procedure and that the patient's questions have been answered. The long form is a more detailed description of the procedure and the information given the individual. A third form, the blanket form, used in routine medical care, is usually signed on admission to a facility. This form gives the agency or physician permission to perform minor procedures. The form has been challenged in court and is not advised to be used. Challenges to consent. The patient must be able to comprehend the consent form and the information. Language may be a barrier. Translator must be provided if the language is not English. The healthcare professional is also responsible for providing language that the patient understands and comprehends. Consent must always be voluntary and not coerced. Medicare conditions of participation, requirements for consent. The consent form must contain the following information under the Medicare conditions of participation for a covered entity. The name of the individual, the hospital name in full, a detailed description of the procedure, the name of the primary care practitioner who will be performing the procedure, the name of any others with a significant role, the risks and benefits of the procedure, alternatives to the procedure, the signature of the patient and the professional person who witnessed the signature, the name of the person explaining the procedure to the patient. The HIPAA preemption rule. HIPAA regulations are preemptive of any state regulations that are contrary to the general rules of HIPAA. However, if the state regulations are more stringent than the HIPAA privacy and security rules and regulations, then the state rules apply. State laws regarding the reporting of public health issues or auditing, licensure, or certification of facilities are not preempted. Types of health information. HIPAA privacy rule defines the designated record set as the individual information that is collected and maintained by a healthcare entity. This includes the PHI of the individual. Protected health information, or PHI, is any individually identified health information as determined by the HIPAA privacy and security rules. Health information is defined in a broad sense to include all information about an individual's health status, including electronic records. Health information may be de-identified for research and data gathering purposes by the removal of information that would clearly identify the patient. Some instances might include providing information for a registry. Types of health information continued. Limited data sets are compilations of information from which the individual PHI identifiers have been removed. The covered entity does not need the permission of the individual to provide this information to third parties. Those third parties are limited to research institutions, public health, and healthcare operations. A business associate may also be provided with this information. Medical record ownership. The medical record, created by the healthcare organization or provider, is owned by that entity. The state establishes the rules of ownership for medical records, not the federal government. The patient, while having an interest in what is in the record, does not have a constitutional right to the record itself. Federal confidentiality rights. In summary, health information is protected under federal law. In the United States, the Constitution provides the individual the right to privacy. However, this right is only related to that violation caused by the government or a governmental agency. The HIPAA security rule establishes the physical security standards for electronic PHI or ePHI. This rule covers both internal communication of patient information and external transmissions. With the advent of telemedicine and other forms of electronic communication, encryption of information becomes vital. As well, in the Agency for Internal Transmission and Storage, passwords and firewalls are required. The privacy rules control the use and disclosure of PHI. The rules were generated under the Privacy Act of 1974. This act governs the type of information that a federal agency may collect about an individual. Certain circumstances allow the agency to disclose information about an individual without their consent. Federal confidentiality rights continued. Covered entities are required to comply with federal confidentiality rights. Those entities or business associates of the covered entities, organizations covered by HIPAA privacy and security rules, and all entities described in the TCS rules. Federal confidentiality rights continued. The Patriot Act of 2001 allows law enforcement to access medical records if deemed necessary for national security. The FOIA allows individuals to gain access to information held by federal agencies. The Medicare conditions of participation require institutions who participate to keep medical records confidential. Federal regulations regarding substance abuse confidentiality relate to treatment provided individuals with substance abuse issues. Federal confidentiality rights. State laws regarding confidentiality preempt HIPAA if those laws are more strict. The agency must identify when to apply which standard legally. The agency does not, then they are liable. If the agency does business internationally, then the stricter law again applies. The minimum necessary rule. The minimum necessary rule applies to the amount of information in a PHI which is disclosed when permitted. The minimum may be defined by a public official, another covered entity, an IRB or institutional review board, approved researcher, or a business associate. The release of the entire record is prohibited by law. The rule also applies to business associates of the entity. Patient access to health care records. The medical record may contain information which, when released, would be detrimental to the patient. For instance, genetic information contained in the record may affect health care coverage or position. Alcohol and drug abuse treatment is by law kept confidential. Psychiatric notes and records as well are kept confidential. The patient may not access psychotherapy notes. A written request to review information in the record must be responded to within 30 days by the agency. HIPAA regulations for access to PHI. The request to view the PHI by the patient must include the following information: description of the information requested, identification of the person requesting the information, who will be receiving the PHI, what is the purpose of this request, a redisclosure statement, an expiration date of the request, and a signature. State law varies by state and is not preempted by HIPAA if stricter. Must have the patient consent to access the PHI, and the minors are treated the same as adults. Mental health records. Alcohol and drug abuse records are only released without consent for a medical emergency. Medical care, audits and evaluations, and by court order. Psychotherapy notes are protected. The patient may be denied access if it will endanger the patient or if the PHI references another person. Access to health information. Genetic information is also protected due to the possibility of discrimination based on that information. Biomedical identifiers are subject to HIPAA regulations. The duplication of the record is the responsibility of the facility. The facility may charge reasonable fees for the duplication, but not for retrieval or handling of the records. A copy service may be used for the duplication. If there is information regarding a business associate, there must be an agreement with that associate as well. Quality Improvement Organizations, or QIO. QIOs are organizations that contract with CMS for performing quality audits. They were established under the Tax Equity and Fiscal Responsibility Act of 1982. They review the professional activities conducted by physicians and providers who receive Medicare and Medicaid funding. QIO continued. The QIO focuses on the following when doing the review. Was the service necessary? Did the service meet quality standards? Would another service that was more economical have been as effective? Business associates. Business associates are defined as those vendors who do business with covered entities under HIPAA. They may be legal, actuarial, accounting, consulting, data aggregation, management, or accrediting agencies. Patient rights under HIPAA. Under HIPAA, the patient has the following rights: to be informed of policies and procedures that ensure the privacy of their PHI. Notice must be given at the beginning of the relationship with the covered entity. The covered entity is required to inform the patient of the uses and disclosures that may be made of their PHI, their rights related to the PHI, the entity's duties related to PHI. Each agency or entity must construct their own notice. HIPAA administrative requirements. The privacy rule. The privacy rule under HIPAA requires covered entities to establish written policies and procedures regarding their medical records operations. Within the entity, there must be a privacy official and a security official. Training of personnel in HIPAA regulations is required and must be documented. Documentation is required in terms of use, disclosure, and protection of the PHI.